I'm Marc Hoag, chair of the Beverly Hills Bar Association's AI in the Law section, along with my co-chair Amanda Harris. And I'm the founder of HoagLaw.ai, where I serve as fractional GC to AI first SaaS companies and tech startups, while spending my nights and weekends vibe coding all sorts of apps, because of course I do. I'm thrilled to announce and introduce our speaker today, Chris Suarez. So Chris is a member of Steptoe's intellectual property practice and a co-head of Steptoe's interdisciplinary AI data and digital working group. He's an outside-the-box thinker with a passion for helping clients understand and manage risks in high technology, particularly technologies in the computer, software, hardware, and semiconductor domains. As an intellectual property litigator, he focuses his practice on patent, copyright, and trade secret trials and appeals before every level of the U.S. court system, including federal district courts, U.S. courts of appeals, the U.S. Supreme Court, the U.S. Patent Trial and Appeal Board, and other administrative tribunals. Chris's experience in district courts litigation spans all phases of litigation, including overseeing fact discovery, taking and defending fact and expert depositions, arguing dispositive motions, claim construction, and appeals, and examining witnesses at trial. So basically all the things. Chris's experience at the PTAB includes cross-examining witnesses and successfully arguing on behalf of his client at the oral hearing. All right, then. Well, let's get started. Chris, thank you so much for being here. Take it away, please.
Yeah, no, thank you so much, Mark, for the warm introduction. It's awesome that you vibe code on the weekends, and really excited to be presenting here for the BHBA. I wish I were in Beverly Hills right now. DC will have to do for now, but it's great to be here and looking forward to talking about this timely topic. So I'm going to go ahead and share my screen, and um, and just so everyone knows, my email is on the first slide, csuarez@steptoe.com. If you have any questions, or have any thoughts after this presentation, I'm happy to hear from you. But without further ado, would love to kind of go into the details here. And so what I'm going to cover is, first, I'm going to talk a little bit about what privilege and work product is, so that we all have a sense of that from our law school days. Then I'm going to go through the big cases, Hepner and Gilbarco. That's why I'm sure most of you are here, because you want to hear about those cases and hear perspectives on what their implications are for your use of AI. Then I'm going to talk a little bit about ethical rules from the model rules of professional responsibility, because you should be aware of those and be thinking about those as you deal with these issues. And then finally, I'm going to provide some reflective thoughts on future implications, that you might want to be thinking about as we go through these issues. And so, start off again, privilege in the work product generally. Um, the privilege is something that's been in existence for a long time, but the seminal case, for those who don't recall from law school, it's certainly been a while for me, is Upjohn versus United States. And what's the point of privilege? It's really about full and frank communication between attorneys and their clients. So what it's protecting is these conversations between us as lawyers, our clients, and making sure that those don't see the light of day, so that you can candidly discuss strategy and those sorts of things. And so that's why the communications must be for securing legal advice, and the privilege is only between attorneys and their clients, and it's held by the client. And because the privilege is held by the client, that means it can be waived. And so how can it be waived? Examples are disclosure of information to third parties. If you just don't assert it, you might produce something that's privileged and to the other side, and you never say that's privileged, so that could be a waiver. And then placing information at issue in litigation can be a waiver of privilege. So, like as a patent litigator, something we sometimes do is we say, "Hey, we got this opinion of counsel, and this shows that our state of mind was a certain way in terms of patent infringement. And so I may want to disclose that and put that an issue in the litigation. In that case, I may be voluntarily waiving privilege. So that can happen a few different ways. Now, how about work product? Work product is a doctrine that was really ensconced in this 1947 Supreme Court decision, Hickman v. Taylor. And the general principle is that materials prepared by an attorney in anticipation of litigation are shielded from discovery. It involves mental impressions, conclusions, opinions, or legal theories. But work product generally is understood as being a bit broader. It can also cover materials prepared by, quote, agents of the attorney. So if you look at the Federal Rules of Civil Procedure, Rule 26B4C talks about the fact that experts can have work product protection. And obviously, as litigators, if we're hiring an expert and they're banding about strategy and creating documents sort of in the lead up to their expert reports and so forth, we don't want those things to be discoverable. Um, and opinion work product receives a higher level of or work product protection than other types of documents. So if it's opinions of counsel reflecting on the strategies and so forth, that often receives a higher level of protection. Now, as part of this intro, I want to make a quick point about pro se litigants, and because this is going to be relevant when we get to the discussion of AI. And Rule 26B3A of the Federal Rules of Procedure says, quote, a party may not discover documents and tangible things that are prepared in anticipation of litigation or for trial by or for another party or its representative, absent a substantial need. Now, I've really placed emphasis on this by or for language because if you read that literally, it seems to suggest that you can't discover things that are made by the party, which could mean it's not just the attorney, right? And so some have argued that that means that there's a broader work product protection that applies to the client in addition to the attorney, but not all the courts actually agree on that. So, but I want you to be aware of the text of the rule. And so this is a very unsettled issue. But this rule is a reason why some people have interpreted Hepner differently or have thought the implications of Hepner are broader or narrower than they might actually be. And so let's talk about Hepner and Gilbarco, these two cases that I'm sure most of you have heard of Hepner, most if not all of you. Some of you may have heard of Gilbarco. But the cases were both decided pretty much on the same day, and in two different courts, two different district courts, and give us a nice sort of compare and contrast to think about this issue of using AI and the risk of waiving privilege and what the future of that's going to look like. And so let's start off with Hepner. Sure many of you have seen this. It was opinion by Judge Rakoff. He actually initially issued the ruling from the bench on February 10th. So there was a hearing, and in the hearing he said, I am going to permit the discovery of these work product documents that were generated using AI. And basically, you had a criminal defendant. He was under investigation, and he decided, without consulting with his attorney, I'm going to use Claude, the public version of Claude, to see if there is anything interesting here in terms of strategies that I can avail myself of. And as a result of that, he generated 31 documents. And I want to be clear with some things up front, because first, if you look at the second bullet here, the court's ruling in the case answered a question of first impression nationwide, or at least appeared to answer that question. And it was very narrow. Whether, when a user communicates with a publicly available AI platform in connection with a pending criminal investigation, are the user's communications protected by attorney-client privilege or the work product doctrine? And the answer, the court said, was unequivocally no. But I want to be clear that the question presented is very narrow. It's about a publicly available AI platform. And the key here was you had the 31 documents, right? The conversations were with Claude. They were not with an attorney. And there was no suggestion from counsel to do this. He prepared reports that outlined defense strategy and outlined what he might argue. And after the client decided to do this on his own, then he shared the documents with counsel and later asserted privilege and work product. All those facts are key here. And so the court said, I'm going to start with the privilege. Okay, so there's a privilege ruling and a work product ruling. On the privilege, the documents were not privileged for several reasons. The first being Claude is not an attorney. Okay. Now, obviously, some might argue in the future that an AI platform is an attorney, but as of now, Judge Rakoff and most of the bar, I think, would agree an AI platform is not itself an attorney, right? And so discussing legal issues between two non-attorneys is not privileged because there's no attorney-client relationship between an AI user and Claude. So that was the first basis for no privilege. The second basis was the communications memorialized in the AI documents were not confidential. Now, this is not without some controversy. I've seen some postings on LinkedIn and elsewhere that don't agree with this, but from the court's perspective, looking at the privacy policy that was operative for this public version of Claude at the time, that the privacy policy made clear that the inputted data was used to train Claude. And so that data was taken in as an input, and the policy said, we're going to use that data. And so it goes into what I call the soup of the AI for purposes of training, which means it could be output by Claude at some later point in time. And so you've kind of given it away, according to the privacy policy. And Anthropic also had a clause in their privacy policy that said they can disclose the information you input into the AI to other third parties for purposes of law enforcement and other things of that nature. And so that's something you're going to have to think about. If you're using a version of some publicly facing AI tools, what does the privacy policy say and what are the implications of that? And of course, one theme of this that I'm building to that I'll repeat several times is that ideally any client who uses this stuff is using a private enterprise version that is not training on the inputted data. That is a way to avoid a lot of these problems. Doesn't avoid all the problems, but it helps avoid some of the problems. And so that's the first two reasons. The third and final reason that the court said was a close call was that in the court's view, Hepner did not communicate with Claude for actually obtaining legal advice. And his argument, Rakoff's argument here, was that there was no direction from counsel to use Claude. And Claude has a disclaimer in it that says, hey, I'm not a lawyer. I don't provide formal legal advice. Now, the way the court analyzed this third factor sounds a little like how he analyzed the first point, but he did recite it as sort of an independent reason. So that's Hepner on privilege. On work product, he said no work product protection either. And I think part of this, I think, is that we need to consider is that, again, Rakoff's in the Southern District of New York. He's applying Second Circuit precedent, right? And so he cited this in re grand jury subpoena. And in the Second Circuit, work product is, quote, not generally promoted by shielding from discovery materials in an attorney's possession that were prepared neither by the attorney nor its agents. So that is a proposition in a precedential case in the Second Circuit, which seems to suggest that work product is focused on attorneys and agents and not on what the client does himself or herself. And that seems to somewhat contradict or at least go against the plain text of that rule of civil procedure that I mentioned earlier. But again, that's what the law is in the Second Circuit, according to Judge Rakoff. So that was part of the basis. And so then he said, even if AI documents are prepared, quote, in anticipation of litigation, they were not, quote, prepared by or at the behest of counsel and did not reflect the counsel's strategy. And so really the ruling in Hepner for work product came down to Claude is not the agent of an attorney. There was no direction from the attorney, and therefore no work product. Doesn't matter to the court that it's done by the client. And that last quote goes to the heart of it. While it is true that the work product doctrine may apply to materials generated by non-lawyers, the Second Circuit has repeatedly stressed the purpose of the doctrine is to protect lawyers' mental processes. So that was really fundamental to Hepner. And so in Hepner, again, no privilege, no work product. The client's efforts to use AI are discoverable. But now we've got another case, Warner v. Gilbarco. And this is Eastern District of Michigan. The opinion came out February 10th, 2026, which is the same day, again, that Rakoff had the hearing before he issued the opinion a week later on February 17th. And so, and Warner, the court denied a request for production of information concerning use of third-party AI tools in connection with the lawsuit. And the court here said the information is not discoverable because under this rule 26B3A of civil procedure, a party may not discover documents and tangible things that are prepared in anticipation of litigation or for trial by another party or its representative. So the emphasis in the italics here is in the original. Okay, I didn't add it myself. And this is underscoring that the court here felt that this rule means that if a party is using AI and doing things in anticipation of litigation, that stuff should not be discoverable. So you can see kind of the split here between the Eastern District of Michigan judge and Judge Rakoff. Um, the court also said the information sought was not relevant, and even if marginally relevant, is not proportional to the needs of the case. And there was no evidence there that the plaintiff violated a PO by uploading confidential documents into AI. Now, I've done some investigation into this case. It seemed that there was a bunch of deposition discovery that was going on where one side was basically trying to see if the plaintiff was pulling shenanigans or putting confidential information into AI that would have violated a protective order. And so that was the sort of thrust of why this AI stuff was being sought here. And so that context is somewhat relevant to maybe why the court was somewhat annoyed that that there was an effort to get these AI materials. I think the court kind of viewed this effort to get the AI documents as a fishing expedition. And so that is relevant. And, look, I think something to reflect on from that is that, yes, the work product and privilege analysis is relevant, but you got to think about the context too and think about the relevance and proportionality because that might be an independent basis to say this isn't discoverable, even if technically there might have been some argument about privilege waiver or work product or what have you. So something to think about there. And the final bullet, I just point out that the court said there's no waiver because waiver has to be a waiver to an adversary or in a way likely to get an adversary's hand, and AI programs are just tools and not people. And so from a technical standpoint, I think there's a fair argument that even if, yes, you're training on the data, you're providing it to a third party in Claude, like is there a realistic possibility that that information is actually going to get into the hands of your adversary or actually be output identically to a third party? Not necessarily. And so I think the court was somewhat appealing to that logic. And then there's also another discussion that's going on in the bar about, well, why should we be treating these AI tools much different than something like Microsoft Word if I'm using that? If I'm using Google Docs, which is a cloud-based tool, is that risking waiver if there's a privacy policy? So looking to those other types of technologies and thinking about AI as a tool, arguably has some sort of connection to pre-existing technologies like Microsoft Word and some of those things. So that's another sort of point of discussion I think we're having in the bar right now. But hopefully this has allowed you to see the sort of contrast that exists between the Hepner decision and another decision. And again, we don't have any circuit precedent on this. And so obviously we have to be mindful of the privilege waiver and the work product waiver risk, and we need to tell our clients to, not go crazy sort of in a rogue way to sort of use AI without discussing with attorneys. But at the same time, we should make it clear to our clients that the law is still very open and unsettled in this area. And so this is exciting and interesting, but we've got a long way to go to so we officially know what the result's going to be. Um, so the last two things I want to talk about before wrapping up are just first, I want you to be aware of some of the ethical rules that I think are implicated by these decisions. And then again, at the end, I'm going to talk about some next steps to think about. So, um, the ethical obligations you should be aware of that you may have heard about before. These are all in the ABA model rules, include first the duty of competence. Uh, Model Rule 1.1 and its comment 8 indicate that lawyers should understand the benefits and risks associated with AI assisted technologies. And so you need to know about the risks and the benefits, and you need to be informed of that. That's why we have CLEs like this, so we all continue to stay informed. Another thing to understand is that there's a duty in the ethical rules around confidentiality, right? Client information should be kept confidential, and so clients should understand, hey, I might be releasing my information to a third party, or to at least to the AI vendor if this AI vendor is going to be collecting my data for purposes of training pursuant to its privacy policy, right? So I need to be aware of that, and I need to be aware of what type of AI system I'm using, whether it's in some sort of protected walled garden or not. And as lawyers, we have duties to inform our clients of the risks of things not being kept confidential. I've even had clients who might get excited to take work product they receive from outside counsel and say, oh, I want to test out how outside counsel's work is, and I'm going to run that through some AI to see if I like the work product. Well, if you're doing that, and you're not doing it in an AI that's enterprise grade and private, your own client can be making a significant mistake there. So we got to inform them of those risks. Another one I want to emphasize is duty of supervision. This has become relevant in light of all the hallucinated cases we've heard about. There's hundreds of them now in the U.S. It's honestly crazy just how many of these we're seeing. And you need to make sure that you're supervising junior attorneys, supervising your experts. There's been situations where an expert in AI from Stanford in a Minnesota case actually had fake citations in that case, and it's because there wasn't supervision. When it comes to these privilege waiver risks, you also need to be thinking about how are you supervising your agents, your vendors, what they're putting into the AI. Are they taking work product and feeding it in because there's some third party vendor or support team of your expert who doesn't realize what they're doing, right? So, like, we got to talk to our clients about this, but we got to talk to the whole circle of people we work with, and especially the senior attorney on the case needs to be supervising it effectively. And then finally, duty of communication. We need to be consulting with clients about how the client's objectives are accomplished. And if they want to be consulting AI to achieve those objectives, perhaps that's okay, but we need to have a window into how that's being done. That's super important. So, finally, in the last 5 minutes I have before I take any questions people have, is to talk about future implications of this that you might want to be thinking about both for yourself and for your clients. And so, first, the law is going to be uncertain in this area. We have, and the same is true for the litigations of generative AI and copyright. I'm sure many of you are following those litigations, right? There are 80 some litigations involving the use of AI training data in connection with copyright. We have decisions, for example, in the Bart's v. Anthropic case from Judge Alsip. We also have a decision in the Cadre v. Meta case. But other than those decisions, we have no circuit level precedent and no other precedent on the use of generative AI and training data on the copyright in the copyright context. So to here, we don't have any circuit level precedent on this work product and privilege waiver issue. And so just keep in mind the law is going to be uncertain. uncertain. Second, in any engagement, I would just make sure you're advising the client on the risk of discoverability of their generative AI use. They might be excited to use it. It might save them some time, might save some money to use AI, but they cannot assume the information that they're putting in or the documents they're creating are going to be protected automatically. There are risks, and so conversations need to be had about what AI tools that are being used, what privacy policies are being used. When you're using the AI tools, is it at the direction of the lawyer, or is it just something they're doing rogue, as in the case of Heppner? Like all of those things need to be discussed so that we can make sure that we're above board on this. Third, it's really important that if the clients are using AI in connection with litigation thoughts or impressions or whatever, ideally those uses would be directed by attorneys or at least, an outgrowth of conversations with attorneys so that that can be connected and tied back to the privilege. That would be the ideal. Next, again, those privacy policies are relevant, at least according to Judge Rakoff. And so, as an attorney, you should be aware of the privacy policies that are at issue in the generative AI tools you're using. You should know that, frankly, for the tools you're using in your organization. But you certainly need to make sure you know about what your clients are using and what those privacy policies look like. And that analysis is going to increasingly be important, especially if Judge Rakoff's opinion sort of carries the day going forward. And then, and it, as I've alluded to several times already, you're going to want to probably make sure enterprise or paid versions of the Gen AI tools are being used. I can tell you from experience that pretty much every unpaid version of a generative AI tools is going to train on the data. That's the benefit of the bargain you get for getting it for free. And that's why it's not technically free, right? And so you want to err on the side of enterprise or paid versions, and you want to ideally keep the inputs and outputs in a safe walled garden that's maintained under lock and key. And you want to make sure that your client's data is maintained in a segregated fashion from other data. You don't want to commingle data either, right? So that's another big issue there. Um, and then, as I alluded to previously, also, the oversight and communication isn't just with the client here. Like I have worked with several clients who haven't given much thought about how are our vendors using AI? How are our experts using AI? How are these other third parties using AI? And you have to really run down that chain. You really have to go back and look at the agreements with these third parties. Like, does your expert retainer agreement have something about AI and how it's being used? You'd be amazed at how few people have actually revised their expert engagement letters, right? And there's also a similar, exercise that should be done with the vendors. That does it mention AI? And does it mention how the AI is going to be used? Same with your agreements. You might have outside counsel guidelines with your if you're an outside counsel like me, you might have outside counsel guidelines. If you're in-house and you're supplying outside counsel guidelines, you might want to be thinking about how you adapt those outside counsel guidelines for purposes of avoiding these privilege waiver risks. And the last comment I do want to make is about pro se litigants, because again, the law is kind of unsettled in this area. And intuitively, it would seem that, pro se litigants who don't have the resources to afford enterprise grade AI, and who are, trying to sort of figure out their case in anticipation of litigation. I do wonder if the law is going to have a place for them in terms of maybe having some sort of exception for pro se. Because if the Rakoff decision is applied to pro se litigants, I could see that having bad implications on the bar and for pro se litigants. That's just my personal opinion, of course. But that's sort of an open issue. And for those of you who may work with pro se or do pro bono work in your practice, that's just something we're going to have to keep an eye out for, because pro se litigant doesn't have a lawyer. If they're waiving privilege and work product protection, and based on these prompts, that might be unfair to them, and it's something that I think we're going to have a conversation about in the bar. So, so with that being said, I do see I'm at my time. I don't know if there's any questions in the chat. Let me just check if there are. Um, okay, there's one question in the chat, so I will answer that before we wrap up. Um, so, so Mark, you asked the question about, doesn't of his own volition conflate initiative with purpose? Um, yeah, it's an interesting point. Look, I think the reason why I think Hepner did the of his own volition, or Rakoff wrote the of his own volition, is because it's so centered on the attorney's role in both privilege and the work product protection, and so I think Rakoff's view is that in the Second Circuit, basically work product protection and privilege, is an outgrowth of the attorney, and so. I agree with you that the purpose of what the person was doing, the client was doing, likely did relate to litigation strategy and was for that purpose. But I think Rakoff exalts this view that the lawyer has it erected. So if you go rogue, then you're going to risk waiving the privilege and work product protection. But I do see your point. I mean, and I think that's why the Warner v. Gilbarco case interpreted that rule more broadly, as also applying to clients, and said, no, 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 I'm not gonna allow this stuff out. So yeah. So anyway, I think it's a great question. And because I'm at time, I'm gonna wrap it up. But I will just say, again, I'm happy to ask any questions, or answer any questions over email. My email is csuarez@steptoe.com. I also do have a newsletter I send out on AI musings, that I send out from time to time. So if anyone who's listening is interested in receiving that newsletter, just feel free to drop me a line at csuarez@steptoe.com. And I would be more than happy to send you my thoughts on random AI topics from time to time, as well as to answer any questions you might have about this particular issue. But with that being said, I'm really thankful for the opportunity to present here to the BHBA. Grateful for the invitation, and look forward to hearing from some of you. And thanks again for the opportunity. Have a great day, everyone.
This concludes today's presentation. Thank you so much, Chris, for an excellent presentation, and thank you so much to our audience. Have a great day, everybody.
Take care, everyone.